Mike O'Neill is an attorney at Landmark Legal Foundation. He's much more than that. He's the guy who knows everything about what's going on when it comes to legal stuff. Mike O'Neill, welcome to the program. How are you?
I'm doing great, Fawn. It's good to be with you.
Thank you. I love having you here because I can ask a question and you will just explain the whole thing. I don't have to think anymore because you just know. So, Are you a dad?
I am, yeah.
And what's the best Father's Day gift you've ever gotten?
Oh, the best that's a great question. Watching the U.S. Open, getting to watch golf all day Sunday afternoon. That's kind of my happy place. So if I get to, this weekend is the U.S. Open at Oakmont in Pennsylvania. So just sitting quietly on my couch, getting to watch the U.S. Open. Does that sound like a dad answer or what?
Well, I've been saying it all week. Your dad just wants you to leave him alone. So I guess I was right. So there. Okay, that's awesome. Well, I hope you get what you want, and I'm sure you will because you just said it publicly, and I'm sure they know. All right, so Landmark Legal, we had some Supreme Court decisions come down.
Yeah.
So some were a big deal, others of less relevant. But when it comes to the Smith & Wesson brands, I think that was Landmark.
Yeah, we participated in a brief in that, and it's an important case, and it's a case revolving product liability. And I know this is something boring, facially, but it's important because what happens here is you always have in lawsuits, in civil lawsuits, you have groups of people trying to assign liability to industries with deep pockets, right? For example, and in this case, what's really interesting is the country of Mexico actually sued gun manufacturers, Smith & Wesson gun manufacturers, trying to hold these gun manufacturers civilly liable for gun deaths in Mexico. So they're trying to have this argument that somehow the manufacturer of a firearm, despite the fact that, of course, somebody picks up a gun and utilizes it, that the individual actually commits the crime with the gun, should be held liable civilly and criminally, of course. But they were trying to make this argument, but the government of Mexico can't sue the individual civilly because they don't have any money. But, of course, gun manufacturers might have some money, and so it looks like the government of Mexico is trying to get a payoff. And so they're saying, okay, we're gonna try to hold these American manufacturers of firearms liable for gun violence in our own country. Well, it makes sense. The advice you say is, well, I don't know, maybe enforce your laws and make efforts to decrease gun law. Exactly.
Stop the cartel.
Exactly. Well, so interestingly here, and this was kind of a good week last week for the Supreme Court. I know we're into Thursday now. We're talking about what happened with the Supreme Court last week, but it's important to note that these opinions, this was Justice Kagan wrote this opinion, and all the three opinions we can even touch on this, in our conversation right now, were each written by one of the so-called liberal justices. So even Justice Kagan recognized limitations on liability here and understood that within the statute, there's a given statute, Protection of Lawful Commerce and Arms Act, it didn't allow a country to hold firearms to sue or hold these firearms manufacturers liable. So a really good limitation on that principle. And again, you can always think of the negative with some of these cases. If the court hadn't ruled as it had, what would have happened? And of course, it would have opened up the floodgates for foreign countries being able to sue American manufacturers in all kinds of capacities.
And liberals suing manufacturers every time something happened, even though it's usually they're Looney Tunes who do that kind of stuff. But
right.
The gun manufacturers make a product. It's like suing Tyson if you choke on a chicken wing. Come on.
Ford Motors. If Ford Motors, if somebody decides they want to buy a pickup truck and run it through a crowd and hurt people, you don't sue the fire. You don't sue the product manufacturer in those cases where there's that sort of action. So absolutely, that's a really important case. One of the more high profile cases last week was a case called Ames versus Ohio Department of Youth Services. This one everybody can really kind of understand quickly. This is regarding discrimination and majority discrimination. So what happened here was a heterosexual white woman sued for discrimination. She said that the decision to not promote her to a higher level, to not to promote her, was made on the basis of her race and her sexuality. And in the particular judicial circuit, federal circuit where she resides, and this case was brought, required her under the Civil Rights Act to impose an additional burden on this woman. So, as a member of a white heterosexual woman, it wasn't enough that she simply showed discrimination. She had to show discriminatory intent on the part of the decision maker. And so that's that's something that an African American or a minority or somebody who might be gay or bisexual doesn't have to meet that burden. So there was a different burden that was imposed, a higher burden that was imposed upon a majority class individual. And, of course, the statute here, and this is the Civil Rights Act, Title VII of the Civil Rights Act, doesn't provide for that. Remember what we always do here, Fawn, is we always look at the law. We actually look at the text of the law, and that's where you go from. What does the law say? Well, the law is very clear in this case. It says any individual, prohibits discrimination on any individual. It doesn't single out protected class individuals. It says you can't discriminate on the basis of race, sex, or gender on any individual. Yeah. And interestingly here, this is, again, credit where credit is due. This is Justice Jackson who wrote this opinion. So take that for what it's worth. She recognized, she engaged in a textual analysis of this decision and said, look, this is how you read the law. This is what the law means. These are the plain interpretation of these words, and that's what it means. And judges don't have the power, judges don't have the power to impose additional burdens on these statutory regimes that are promulgated by Congress. So you go from the law. So important here in the fact that it rejected the judicial activism of the Sixth Circuit that had imposed this additional burden. And interestingly, again, I go back to the fact that this is Justice Jackson who wrote this. And so when Congress writes laws that are clear and leave no options for wiggle room, and again, it's good to see Congress writing clear laws, any individual, you can't interpret that any other way, right? Mm-hmm. And so even Justice Jackson, who might be predisposed to rule in a particular manner, doesn't have any wiggle room. And so to her credit, she ruled accordingly.
Yeah, I think it's great because we're all made in God's image, no matter what group we fall into. And to constantly hear from certain groups of people that we are somehow privileged because we're white, that honestly may have been true at one point in time, but this is 2025. And people don't see with those same kind of goggles anymore, at least not in my house or anybody I know. Nobody does. And so the people who still do are just a little bit, back in time. But the courts, the laws, they apply to everybody. They're not from 1966. They're for everybody, and it's 2025. All right. Now, this is a big one because I am very Catholic.
Good. Yep.
And the Catholic Charities Bureau Incorporated and the Wisconsin Lab and the Industry Review. Just go ahead with that one because this was important to me as well.
Right. This is a religious liberty case. This is a case where the Catholic Charities in Wisconsin had applied for an exemption, a state employment exemption, a tax exemption. So they wanted, as a charity, you're permitted to have tax exemptions. So they wanted the state tax exemption, and the Wisconsin Bureau, the tax division, state of Wisconsin. Let's just boil it down. The state of Wisconsin said, oh no, you don't qualify for this charitable deduction, this charitable tax exemption, because you don't rise to the level of a religious organization. This is something that was provided for religious organizations. So look on the face of this. You have the state of Wisconsin telling Catholic Charities that they're not a religious organization. That's absurd on its face. And what happened was the state of Wisconsin was engaging in this test where they were imposing this test on religious organizations, and one of the impositions was you had to engage in proselytization. In other words, Catholic Charities, Wisconsin said, well, you don't try to convert people who come into Catholic Charities for benefit. So if the Catholic Charities is running a soup kitchen, for example, Wisconsin was saying, well, anybody who comes in for food on your soup kitchen, you have to try to convert to Catholicism. And because you don't try to convert to Catholicism, that means you're not a sufficiently religious organization for purposes of receiving the state benefit. Well, that's absurd, right? They're trying to impose a judgment from the state about what constitutes a religious activity for the Catholic Church, for Catholic Charities. And the Supreme Court said, no, you can't do this. This is Sotomayor, so here we go. We've got one from Kagan, one from Jackson, now another one from Sotomayor. Sotomayor said, no, we do not, in our country, we do not have state entities, do not decide whether a religious organization like Catholic Charities, for heaven's sakes, is engaging in sufficient religious activities to constitute this. On the face, they are a religious organization. They are affiliated, deeply embedded with the Catholic Church, for heaven's sakes. We all know this. Anybody who's ever gone to Catholic Church or any Catholic Charities event knows that it's a Catholic organization, despite the fact that it doesn't proselytize and try to convert anybody who walks in to receive clothes or receive benefits or receive a meal. that doesn't mean that it's not a Catholic organization, a religious organization. And Wisconsin doesn't have the authority it's unconstitutional under the First Amendment to come in and try to decide what rises to the level of sufficiently religious to qualify for this benefit.
Well,
so to her credit, again, you had Sotomayor writing this decision. Good decision from the court.
Very much so. And, the people who do come to Catholic Charities for help, as Catholics, we don't care that you're not Catholic. We see you as a human being.
Exactly.
And we're not going to say, get baptized right now or we're not going to feed you. I mean, what do you want us to do? Right,
exactly, and that was very clear from the record at oral arguments. It's essentially what you just said, Fawn, is that it's outreach to the community. It's not, and again, they're obviously it's
close. Shame on Wisconsin. What's going on up there? They've lost their cheese heads.
When you get the Supreme, I think their Supreme Court tends to be. I think it's elected, and there's always the swing. Remember the voting cases. Wisconsin's such an important case regarding voting, and Wisconsin's always swinging about whether they're going to have certain protections for their voting processes in place. But then you have new Supreme Court comes in because they're elected in Wisconsin, and then suddenly they find those all unconstitutional and they revoke them. So Wisconsin's in that area where it's kind of. One day it's doing the right thing. The next day, a new Supreme Court gets elected into Wisconsin, and everything goes crazy. So you never really know what you're going to get up there.
I would hate it.
That was again. Here we go. All three of these opinions, Fawn, were unanimous opinions. Interesting here, all three of these opinions were merits opinions. This is the time of the year when we get the traditional merits cases decisions. There's some more decisions that are going to be coming out in about 5-10 minutes. So what this reflects is a good thing, is what happens when you actually have the opportunity to litigate these cases and argue these cases and brief these cases on a merit standpoint, rather than all these cases we're hearing about on expedited process where you're swinging one way for another. This injunction's improper, this injunction's proper, we're going to say this injunction. So kudos to the fact that the process, at least in regards to the cases, these three cases we're talking, did what it was supposed to do. You had these wrongs that were clearly remedied by good decisions from, again, credit where credit is due, the liberal block of the Supreme Court. There's something to be said, maybe this is the quiet before the storm when we see the unanimity and we're going to get, all these 5-4 splits coming down the pike in the next couple of weeks. But three important cases, three liberal justices, good opinions for the country.
Well, and there have been, in all of these, precedent has been set, so I don't even think there was an argument.
Right. The big takeaway is that Title VII case, and that's the civil rights case, because that's the discrimination. And now you're going to see resoundingly the court has spoke fairly forcefully. When you're talking about cases in the Civil Rights Act, you can't impose any of these additional burdens. You have to if you discriminate on the basis of race, whatever that race is, that's a violation of the Civil Rights Act. If you discriminate on the basis of gender, whether you're discriminating because somebody's a man or a woman or whatever have you, then you're discriminating on the basis of gender. Similarly, sexuality. It doesn't. If you're promoting somebody, if you're demoting or terminating somebody because they're a heterosexual, that's a violation of the Civil Rights Act. So that's a big takeaway, and I think the court spoke fairly definitively on that one.
And I love it because civil rights are for everyone. Not just minorities, but frankly, she's a woman, so she would have been a minority anyway. How are women a minority when we're a larger part of the population?
Again, the point
percentage.
is, back when all this was done, it was to remedy the this is 1964 when this law was passed. And so, I mean, again, you don't quibble with it at the time. Women were being subject to all kinds of, women's and African Americans, minorities were subject to all kinds of discrimination. So at the time the Congress passed the Civil Rights Act. Now you've seen it swing the other way and used as a cudgel against the majority classes, quote unquote.
Yeah. Well, I think it's awesome. I'm glad all three went the right way. And if anything's going to happen in a kumbaya moment, I'm glad it was these three cases. And I'll be in touch with you when the next ones come around.
Yeah, and we haven't even touched on all the riots and all the legal stuff with that. If you ever want to talk about that, that's knee deep in that. But just rest assured that Donald Trump, just quickly, Fawn, for your listeners and you, Donald Trump is on strong legal footing with his invocation of Title X, utilization of the National Guard. The case that Gavin Newsom and the Attorney General of California are bringing is completely a waste of time. Should get thrown out immediately. The president has plenary power to do exactly what he's doing. So.
Make his wife give me her purse for wasting our time. Let's do that.
Yeah.
But yeah, you know what he said? All you did was cause problems. No, we came because you didn't take care of the problems. That's how it went down. And it's not fascism and it's not martial law. There's a curfew because y'all are acting like animals. And if you'd stop acting like animals, we wouldn't have to treat you like animals. So
and by the way, the curfew is imposed by the mayor.
Yeah.
For heaven's sake, how on one hand do you say, "Oh, there's nonviolent protests," and on the other hand, you impose a curfew? Okay, so actions speak louder than words here, and the federal forces, the troops that are used, the National Guard, and the Marines that are being used, are used for security purposes.
Yep.
At this point, they're not used for law enforcement purposes. They're ensuring security at federal buildings, and they're ensuring that we don't have a repeat of what happened in 2020, right?
Yeah. And I've got to hurry, Mike. I've got to hurry here.
All right, I'll let you go, Fawn. Good to talk to you.
You too. Bye-bye.